Hello there, welcome to Case by Case. You've got Calum and Luke Zadkovich here. We'll be taking you through an interesting general average case today. Welcome, Calum.
Hey Luke. Hello everybody listening in.
Well, I'm interested for this one, Calum, because it's our first look back case.
Yes, and they don't come up too often, general average. But in response to a request, we've dug out a recent Supreme Court general average case to kind of look at general average through that lens.
Yeah, exactly. It's good to be getting some requests, some karaoke requests. So let's get into it. This is the LONGCHAMP decision. It's a few years old now. I remember this coming out because it coincided roughly with the launch of our firm. So it's about 4 years old, this case, as are we. So it's a Supreme Court decision. It's the Mitsui v. BLPG tanker float decision. 5 lords gave the decision: Newberg, Berger, Muntz, Clark, Sumption and Hodge, and it was handed down in October 2017. Calum, would you like to give a summary of the facts of this one?
Yeah, let's talk through the facts to start with. So this is a general average case, and I'm going to park exactly what we mean by general average for those not completely familiar with the term. We'll come back to that. But what had happened in this case, in 2009, in January of 2009, the vessel, which was a chemical carrier, was sailing through the Gulf of Aden, and it was attacked by pirates. So pirates came on board, they were heavily armed, and they demanded a ransom of $6 million. There was then a negotiation period of around 51 days, and the ransom demand was watered down to $1.85 million. And owners said that the owners declared general average and essentially said that all the parties who had an interest in the maritime adventure had to contribute to the payment of this ransom amount. And they also included in their general average, in their declaration of general average, the negotiator's fees, as well as the cost of running the vessel, the kind of vessel's operating expenses for the 51-day period during which the negotiations took place. And actually, in the context of a reasonably large sum, being the 1.85 million plus the negotiator's fees, plus the 51-day operating expenses, those operating expenses were the only thing that were really in dispute. The ransom itself and the negotiator's fees, the parties had agreed, fell within what could be claimed under general average. And it was just this question of that 51-day negotiating period. Were the vessel expenses during that period part of the kind of general average? In very short, that was what the dispute was about.
Yeah, exactly. So we have a Supreme Court decision. So it's the highest court in England, dealing with a claim for $160,000. And while that's not pocket change in the scheme of piracy and general average cases, that's certainly at the lower end of the range. And one of the things that struck me is why is this being taken all the way up to the Supreme Court? It would have been backed by an insurer who didn't want to pay on the cargo interest side. So why is it getting to the Supreme Court? And I think the answer to that is precedent, and that if this was accepted by the insurers, in the negotiations, what kind of precedent does that set? Now, whether they're pleased that they took it to the Supreme Court and got the ultimate decision, we'll come on to in a moment. But it did strike me that the quantum involved was surprising.
Yeah, although the Parking Eye case, which is the case on liquidated damages provisions, the Supreme Court judgment, I think that was in 2016, that went to the Supreme Court over, I think, it was an £80 parking fine, and they went all the way up on that. So compared to that, this is...
I remember that.
This is significant.
Yeah, that was the penalty case, wasn't
exactly.
it? Whether a parking fine was a penalty. Yeah, exactly. That's right. I remember that decision. Well, okay, general average. I suppose we should really start there. What is general average?
Yeah, and fortunately for us, Lord Neuberger deals with this at paragraph 2 of the judgment. So I'm just going to take his description because it's better than I can do. He says general average refers to the system of maritime law by which sacrifices of property made and loss and expenditure incurred as a direct result of actions taken for the purpose of preserving a common maritime adventure from peril are ratably shared between all those whose property is at risk in the adventure.
Yeah, so the key points there that I kind of take away from that description are loss and expenditure incurred, and then for the purpose of preserving a common maritime adventure. So it's not just losses that are incurred, but it's also expenditures. It's also sums that are paid, not just losses, and that's important here. But it's the concept, and for those that are listening that don't come across general average all that often, and it's not a very, very common case that you see in shipping, but it does arise. And we've had a very large, well, one of the largest ever high-profile public casualties in the Suez Canal, the Ever Given vessel, which I think is what prompted the request that we had for this podcast in the first place, where the Ever Given was stranded, cutting off the Suez Canal for almost a week with 18,000 containers on board. That vessel declared general average, the owners declared general average, and no doubt that's going to take years and years to sort out through the general average cases that flow from it. But if you look at that case as an example, the Ever Given, just in terms of understanding the general average concept, to get the vessel refloated and unstuck from the canal, there was a lot of salvage and cost that was put into that extra expense, money paid to get the vessel sailing again. And so that was for the benefit of not only preserving the vessel itself, but also for preserving the cargo. And so it's this general average deals with a concept by which when steps are taken by the owners of the ship to preserve the common maritime adventure when property is at risk, when they make those expenditures or suffer losses, they can recover from the cargo interests a proportional amount of the value of that cargo, and that proportional to the value of the ship in general average. So it's almost like a no-fault mechanism for gathering up a pool of money from everyone who had property on board the ship to say, you all need to kick into this in a percentage that accords with the value of your property involved in that vessel.
The one other point that I think is interesting in general average is the expenditure has to be incurred as a direct result of the action taken for the purpose of preserving the rest of the property on board the ship. And I had this best explained to me when I was a trainee. I was imagining a hypothetical situation where there is a cargo hold which is full of containers, and around a third of the way up there is a container which catches fire, and it causes a bunch of fire damage to the containers directly above it. And in order to stop the entire ship from being set on fire, the owners take the decision to flood the hold. And they flood the hold up to the level of the containers. Say the first 3 layers of the containers are all flooded, they're all submerged. Now, in general average, all of those containers that were damaged by the fire, that fire damage wouldn't fall under general average. It's just fire damage. It's caused by the fire in a container hold. But all of the damage, all of the water damage from the flooding, all of that is general average, because that's what's done to preserve the rest of the voyage. The fire damage is just simply caused by the fire. The water damage is in order to preserve the rest of the cargo in all the other cargo holds. And I think that distinction is quite an important one, and that's quite a neat way of explaining it.
I like that. That is a neat way. So, yeah, it's also a very old concept, isn't it, general average?
Yes.
It goes back to, and this is mentioned in this decision, it goes back to at least the law of the Rhodinians. Having been adopted by the Romans, it was passed on a customary basis into European sea laws of the Middle Ages. And then it found its way into the modern European codes. And I think in England, it first was mentioned judicially in an 1801 decision of Berkeley and Presgrave, by Lawrence J. And then statutorily, it was enacted in Section 66 of the Marine Insurance Act 1906. So it goes back a long way. Similarly, on the US side, it also has been a foundation of US law for a similar period of time. And the other point to mention on kind of sources of general average law, and law is not really the right word to use there, but sources of general average principles are, of course, the York-Antwerp rules. And those are an internationally agreed set of rules, first propounded in 1877. And those are not, it's not force of law, it's not a convention, it's not a statute of English law or others. What it is it's an internationally agreed set of rules which seeks to achieve uniformity in ascertaining what losses fall within the general average principle and how to calculate those losses. And so the York-Antwerp rules, which you will hear a lot about in the context of general average, actually comes into contracts by incorporation. So the parties have to agree to incorporate the York-Antwerp rules into their charter parties and then into the bills of lading, which will be the contract between the cargo interests and the carrier.
And you do see very frequently, almost ubiquitously, that the York-Antwerp rules are incorporated by agreement. But it's an interesting point. It bears repeating that these laws have no effect save for the effect that the contracting parties give them. So they have to include in their contract general average is determined on the York-Antwerp rules. And when they do, they bring in all of the law associated with the York-Antwerp rules. They incorporate that entire regime into the agreement.
Yeah. So in this case, really the starting point is to look at the York-Antwerp rules. And so as Calum explained, the two parties are arguing over what can and cannot be recovered. The owners are wanting to recover their vessel operating expenses and at least a proportion of that from the cargo interests. And cargo interests are saying, well, no, you can't recover your operating expenses because they do not fall within the York-Antwerp rules for allocating general average expenses. And we'll get into the specific rules in a moment. But that at a threshold level, that's the argument that we've got going on here.
Yeah, exactly. And the case, this case turned on Rule F. And Rule F of the York-Antwerp rules essentially says that where a party incurs an expense in place of a different expense, and the expense that they kind of could have used but chose not to would have been general average, and the expense that they did incur instead was less than the amount that they would have otherwise incurred if they'd followed the normal general average path, that additional expense, that kind of unusual expense, if you like, the term in itself is up for debate, but that different expense that they incurred can form part of the general average contributions. And in this case, the owners said, well, option A that was open to us was simply paying $6 million. We had the pirates came on board, they held the crew hostage, they demanded $6 million. So our first option is paying a ransom of $6 million. But instead, we took a second option, and that second option was negotiating for 51 days to then pay $1.85 million. And they say this period during the negotiations, this 51-day period of operating expenses that we incurred, was incurred in the place of simply paying $6 million. And therefore, it falls within the general average regime, and the cargo interests have to pay their share prorated to their interest in the maritime adventure.
Yeah. And cargo, they were saying, no, this is not a general average expense, because while Calum's framed it as option A and option B, what actually happened here was that the vessel continued to incur the usual operating expenses that they would incur, and also that the initial sum was unreasonable, the ransom sum. So there's a real dichotomy here. It seems that the court, well, it was a 4-1 decision, was moved by the owner's position and in effect went through Rule F and found that it doesn't go to the question of quantum. It goes to the nature of the expense that was allowed. And so owners, when they're trying to cap or trying to introduce the question of quantum into the first part of Rule F, that's not what the drafters of the rules were intending to do from the court's perspective. And they went through a number of reasons for that. Number one, they looked at the word allowable in Rule F, and that takes you in an analytical way to Rule C, which is dealing with what is allowed, and that's rather than looking at the Rule A analysis. The second reason for this decision was that they looked at the opening part of Rule F, and that's where they said that the opening part of Rule F, and perhaps we should just read that so we've got that to hand. Rule F says that any extra expense incurred in place of another expense which would have been allowable as general average shall be deemed to be general average and so allowed without regard to the saving, if any, to other interests, but only up to the amount of the general average expense avoided. So you can hear that in the last part of the clause where it says only up to the amount of the general average expense avoided, that introduces the notion of a cap. So the extra expense that you can recover is capped at the amount of the expense that you are avoiding. Okay, so there is a quantum cap built into this clause in the last part of the clause. But what the court's saying is in the first part of the clause, it does not follow that you should be introducing a new quantum analysis or placing some quantum component on top of any extra expense. The court then went on to say that the third reason is that this construction that the cargo interests are pushing brings in an unnecessary limitation on what is allowed as an extra expense. And finally, to kind of hit the nail in the coffin on the argument, the court found that this construction, so owner's construction, is an entirely rational outcome. And by that, what they mean is that the extra expense is not allowed or not allowed because of how high or how unreasonable the expense avoided is. It's an irrational suggestion to make, well, if the expense you're trying to avoid is very high and you then do it successfully, and it was an unreasonable amount in the first place, that you shouldn't be able to recover that extra expense. But if it was a reasonable amount, if it was a lower sum that you were avoiding, then you are entitled to recover the extra expense. And this was the Hudson conundrum, Calum.
Yeah, the Hudson conundrum. And yeah, so that when I read through this judgment, I read the majority decision and I thought, fair enough, that all makes a lot of sense. But the point that I couldn't really shake is that, at least it seemed to me, that 6 million was surely fanciful. The pirates come on board and they start the negotiations at 6 million and they say, I want 6 million. And you say, okay, well, looking at the value of the vessel and the cargo, actually 6 million doesn't make a lot of sense on any basis. Couple that with the fact that, I don't know if I can speak for pirates generally, but I think it's fairly safe to assume that the pirates didn't come in with a sort of take it or leave it offer. I think everyone would appreciate and understand that the pirates were highballing, to say the very least. So the idea that $6 million payment could reasonably have been paid and claimed in general average, or it would have been allowable as general average, I find slightly difficult. I know the majority decision drew this distinction between what would have been allowable, a category that could have been allowable, and what would have been allowed under Rule C. But where I think that gets complicated, and where I think this dissenting judgment of Lord Mance makes a lot of sense in this case, is that he says in order to kind of trigger Rule F, you need to have two competing kind of strategies to take as the owners. You've got the first option, which is the normal option that everyone would take in that situation, and then you've got the option that owners in fact take in this particular situation in order to avoid taking the kind of the normal path. And where the owners take the second path, then they can pass on the costs incurred with that second path in general average. And what I suppose is the crux of the issue, and what I didn't quite see in this case, is that there really was a difference between the two paths. I don't know if there really was a credible option of simply saying we're going to pay the $6 million and call it there.
Well, it's an interesting point, because both the courts of first instance and the Court of Appeal thought that it was a reasonable sum to pay, and there was some factual issues here involving one of the sailors, I think, was unwell. There was perishable goods on board, and the Supreme Court was reluctant to disturb those factual findings. But they did say it wasn't a fundamental fact that had been decided in the case, and then made some comments. And I think Lord Neuberger came at it in a similar way to you on the factual point. But what do you make then of Lord Sumption's argument during the course of the oral arguments, which was noted in Lord Neuberger's decision? And that is that if this argument about the unreasonableness of the expense to be avoided has some force, what about when that sum gets down to a reasonable level, and then the cap, the kind of reasonable cap, if we can call it that, becomes the cap for what the extra expense recovery is. So to use kind of the example here, if the original ransom sum was $6 million, and you say, okay, that was unreasonable, so that shouldn't be the cap. If that's negotiated down to $4 million and a $4 million level is reasonable, doesn't that then become the cap for the purposes of the second part of Rule F?
Possibly, yes. To me, you still need the two competing courses of action. So you would get you would have the ransom demand would come down to a quote unquote reasonable level, which I'll come back to in a second. And at that point, owners would then have a decision to accept the reasonable offer or to push for the extra reasonable offer of even less. But I don't know whether what I wasn't sure about in the judgment in respect of that kind of argument is, does that entitle owners to the full 51 days? Because as of day zero, the offer on the table was $6 million. So if we're saying that's not reasonable, then the full 51 days don't get covered. The time only starts when the reasonable offer is made to owners. And then on the reasonableness point, I actually agreed with Stephen Hofmar QC, sitting as the deputy judge in the High Court, to say, well, what are we doing, saying that these are reasonable ransom demands made by pirates who have come on board a ship heavily armed, taking the crew hostage? What part of that is reasonable? It's laughable to suggest that these demands are reasonable. Surely they might be kind of commercially palatable in order to just resolve the whole situation, but the concept of reasonableness, I think, is actually quite a difficult circle to square with the context of a ransom demand made by pirates.
Yeah, I take that point. I think that's it's a fair one for sure. But so you're stuck on this alternative course of action argument, which was the second argument that the court dealt with. And I think the court had difficulties drawing the line between what would be an alternative course of action, where, in the way you framed it, what's option A and option B, and you have to have two different options that are taken to fall within the principle. They thought as I read the judgment, having these kind of two competing options which you needed to take, or at least take a different one than the normal, could lead to some absurd, might be putting it too far, but some interesting scenarios, and ones where it's quite difficult to distinguish what is the alternative course. And they then went through the drafting of the York-Antwerp rules and couldn't really read into the rules or the development that it was justified to have such a strong principle. And that was over the top of at least two of the leading texts, and I think it was a Hamblin decision, which had, although that decision, you'll probably have the case name there, but that decision didn't deal with it squarely. I think it was an obiter issue, or at least it wasn't the ratio of that case. the court found that to have such a pronounced principle as an alternative course of action was not justified. So are you saying you don't agree with that?
Yeah, I think so. I think I agree with the dissenting judgment that is the effect of the rule. That's what those are the expenses that this rule is trying to is trying to cover. I mean, I'm clearly wrong because the Supreme Court says otherwise, but that's how I figured it when I sort of was reading through it, and I felt like the Mance dissent was correct on it. It does raise a very important point of general application, which is that when these cases get to a court level, any case, especially in perhaps younger industries and sectors, and I'm thinking in particular the LNG sector, where there's a very clear kind of set of commercial quote unquote rules. They're the ways that parties contract and what parties kind of understand clauses to mean. That all goes out the window when you get to the court, particularly when you get to the Court of Appeal or the Supreme Court. And the bench in this case made that pretty clear. They said, look, you may have the established way that average adjusters deal with these kind of with these kind of amounts and these kind of expenses, but we're not here to just look and give effect to the normal way that these expenditures are divided. We're here to make a judgment on the law, and that's what we're going to do. And they kind of rode over what the normal commercial position was, and I think that's quite instructive.
Yeah, which brings us on to, I think, what are the takeaways from this case, and perhaps more importantly to a lot of our listeners, how do we deal with general average cases? Because we've got a decision here that's gone all the way up to the Supreme Court, and there's been a decision on the construction of a particular rule of the York-Antwerp rules, and even as we discuss it here, we're not entirely convinced by the decision from a legal perspective. I think I fall with the majority on this one. Sorry, Calum. Well, that's good to have one that we don't agree on.
Exactly.
But you're in good company with Lord Mance there, so
it must be up for debate. If it's gone to the Supreme Court and they've managed to split the bench, then at least it must be debatable.
Yeah, I'll concede that point. That's for sure. For our listeners, for client listeners, those that are out there in the industry that might be facing a general average claim or might wish to bring a general average claim, how do you deal with them?
Right, and this I think is super important because you're in a situation here where you've put your cargo on board a ship. Something has happened to the ship or to some other cargo on board that ship. Nothing to do with you, nothing, not your fault, not your concern whatsoever. And suddenly somebody is waving this 1,000-year-old law at you saying they're declaring general average. And the next thing you know, they're going to exercise a lien over your property. They're going to hold the cargo on board the ship until they get security. I think it can be quite a difficult piece of law for people to kind of grapple with, because it's at odds with a kind of, I don't know, maybe a normal conventional understanding, which is that you have to pay if you've done something wrong, and often with general average you have to pay simply for having things on board the wrong ship. Thinking about all those cargo interests on board the ship stuck in the Suez, they're suddenly being faced with these demands for general average security. And what do you do in that situation? And I think the first point to note is that it's very, very difficult to resist the demand for general average security. That the owner, in a general average, in a case of general average, the owner kind of automatically has a lien over all of the goods on board. The owner is actually obliged to obtain general average security. So the owner can't let the cargo interests cargo off the ship without getting that security. So the first thing I think is you or your insurer has to be putting up the general average security, and I think it's important to note that doesn't necessarily prejudice you from arguing against the contribution. It just means that you've provided the security that the owner is obliged to obtain on behalf of all of the different parties to the maritime adventure.
That's an important distinction. So What you're talking about there is the difference between posting security for the general average claim and then defending substantively the actual general average claim that comes through in due course.
Exactly. Or
those are two different things, right?
Or even litigating after the general average claim is resolved. And there are 2 points there.
Yeah.
The first is what we've seen in this case and what we've been discussing, and that's looking at the concept of, does this loss or does this expenditure fall within general average? Is this something which I, as a cargo interest, have to contribute to because I'm compelled to by the York-Antwerp rules as incorporated into this contract? That's the first kind of question. The second question is, do I fall into some kind of exception? Is there an exception that I can rely on where, even though this might be a general average expenditure, I can resist the demand to pay for it? And there you're into concepts like actionable fault, where if you would have a claim against the party seeking general average contribution for you in respect of the same action that caused the damage for which they're seeking the general average, then you can tell the owner, and it would normally be an owner who's seeking the contribution, that you refuse to make the contribution because the general average expenditure arose as a result of their actionable fault. And the final thing, sorry, go on, Nick.
No, let's keep going.
I was going to say the final point is that any general average contribution that you make is without prejudice to you then litigating issues. So you can still litigate an issue against an owner having given them a general average contribution, and you can include in your damages claim against the owner the contribution that you've made. So there are a number of different steps. It's not quite so simple as saying GA declared, we pay security, and from that point we basically paid everything. There's actually a number of steps, but the first one is by far the hardest one to resist as a cargo interest, and that's getting the security posted to get your cargo off the ship.
Yeah, I entirely agree with all of that. That's well explained, Calum, if you don't mind me saying. The other point that I would make, and this is particularly from the perspective of a cargo interest facing a general average situation or a marine casualty, which is what these are, a marine casualty situation. And that is evidence and understanding what has actually happened here. And for me, in handling these types of casualties over many years now, understanding what has happened is vitally important. Now, the owners and the vessel have an advantage here, of course. They are the ones that have the crew on board, the master on board, so the witnesses who have seen what have happened will be on board. Okay, if it happens by a quayside, there might be stevedores or someone else involved. But typically, the people who know what happened will be on board the ship. The data is on board the ship. Emails that go in and out, they might be kept elsewhere back in the head office of head owners, but emails and correspondence will be on the ship's computers. Logbook, ICSID data, the actual recordings from the bridge about what's said between the pilot and the master. That's all recorded, although it's important to gather that data often within the day or two before it's re-recorded. There's a raft, a whole host of pieces of information that will be gathered in a casualty situation. And from a cargo interest perspective, depending on your stake in that adventure, and assuming you've got some valuable cargo on board and your GA contribution could be quite significant, then it will be worth considering whether to take some type of action to investigate what happened. You would hope, you would want to think that there would be cooperation and there'd be a full investigation, but it doesn't always happen.
Absolutely. And you, as an owner, sometimes, I've been in situations before acting for an owner client where we would create a kind of database of the key documents and open it to any of the cargo interests, because you're facing so many different demands from cargo interests for these different documents, that the starting point, and this is kind of in the container ship context rather than the bulk ship context, where there be far fewer cargo interests, but in the container ship context where there are potentially hundreds or thousands, then one way of dealing with that is if acting for an owner is creating some kind of database and just making it open to anyone who's invited to go in and to search for the documents that they need to, that they're bound to be requesting. And the same goes the other way around. If you're acting for the cargo interest, then it's getting those document requests off, making sure that owners can at least evidence to that prima facie level that there is a right for them to demand the security.
Yeah, exactly. Very interesting, Calum. Thank you for your time today. Did you have any final remarks on this? I think it's been a good one to explore just the tip of general average issues. It's a topic that has a lot of nuance involved. It turns on the reading of the actual York-Antwerp rules, if incorporated into the contract, which is contractual interpretation. Some curly issues can come out of it, as we've seen in this case. But also from a practical perspective, I think we can learn a lot from our experience over the years and sharing some of the practical guidance with our clients. So if you'd like to know more about a general average, feel free to contact Calum or myself, Luke Zadkovich. It's been great having you on listening in today for this podcast, and we would very much welcome you to subscribe and follow us wherever you listen to your podcasts.
Yeah, thanks, Luke. And the only thing I'd add is clearly from this podcast, we are now taking requests officially. So please do send them in.
Thank you. Until next time, goodbye.